Good afternoon to everybody, members of the public, colleagues from the AGE, and of course the candidate. The advisory group of experts is in full composition, gathering today to continue with interviews with candidates for the position for judge of the Constitutional Court of Ukraine. And our next candidate is Mr. Roman Alexandrovich Yaromenok, the senior detective of the National Anti-Corruption Bureau of Ukraine, who was admitted to the competition by the Verkhovna Rada of Ukraine. Hence, I'm passing the floor to the advisory group of expert secretary, Mr. Yaroslav Romaniuk, to moderate the interview. Please, Yaroslav, yours.
Thank you, Mr. Chairman. Good afternoon, Mr. Roman. Good afternoon, the members of public, dear colleagues, and all those who are watching this streaming. Mr. Roman Alexandrovich, the AG in its full composition is here for the interview with the candidates. These are Mr. Chairman of the AG, Mr. Ales Zalas, AG members Ms. Hanna Sukhotska, Ms. Marina Connor, Ms. Oksana Vasilchenko, and Ms. Natalia Kuznetsova. Also substitute members of the AG are here, Mr. Thomas Griffith, Mr. Richard Barrett, Mr. Marek Zubik, Mr. Vasil Shakun, Mr. Volodymyr Kuzmenko, and me, the Secretary of the AG, Yaroslav Romaniuk. We have had time to accumulate information about your candidacy, and we would like to express our gratitude to your communication with the AGE and for your answers that you provided us with. But today, we want to clarify some answers to our question posed before, and also we would like to give you an opportunity to refute or clarify any doubts about your high moral qualities that are necessary for the position of a judge of the Constitutional Court of Ukraine. I am hereby drawing your attention to the fact that candidate may not provide information, documents, or other materials during the interview if the advisory group had requested this earlier and the candidate hadn't provided them at his or her own initiative earlier. At the same time, if considered justified, the advisory group may allow for exceptions. Also, I would like to inform you that the interview is recorded and broadcast live at the AG resources and the website of the Constitutional Court of Ukraine. I'm also drawing attention of the AG members and you to the restriction concerning the use of sensitive data and information with restricted access during live broadcast. If there is such a need, we just stop the broadcasting and discuss it in here. Please pay attention that the interview will last about an hour. I ask you to be concise and take into consideration that the estimate time for your answer to a question is up to 3 minutes. The international members of the AGE are English-speaking, so please use the headset with simultaneous translation into Ukrainian if needed. Blue light means Ukrainian channel. So please don't hesitate to use the headset if needed. At the end of the interview, the candidate may say concluding remarks lasting up to 5 minutes. And now we're ready to start the interview with the candidate for the position of a judge of the Constitutional Court, Yaromenok Roman Alexandrovich. The reporters are Mr. Ales Zalas and Ms. Natalia Kuznetsova. I pass the floor to the rapporteurs for starting the interview. Please, the floor is yours. Mr. Secretary, I will start. Mr. Roman Alexandrovich, the advisory group knows that during the period of your work in the prosecutorial bodies, you were brought to disciplinary responsibility at least twice, in 2009 and 2011. In your answers to the advisory group's written questions, you gave some explanations about these facts. We would like to clarify some of your explanations. At first, with the order of the prosecutor of Poltava region, as of 10th of April 2009, you were brought to disciplinary responsibility for the loss of official documents. You claim that these documents were subsequently found under circumstances which are unknown to me. At the same time, according to your written explanations, documents were lost in 2005. Which means that you were brought to responsibility with a significant violation of the term. In connection with this, please explain where and how you found out that the lost documents were found. Please switch on the microphone and put it closer to give us possibility to hear you. So I found out only in 2009 that these documents were found when I worked in other prosecutor's office, not in the prosecutor's office of the city of Kremenchuk. I was offered to provide explanations. I provided my explanations that I couldn't explain anything because since the moment of the event, 5 years passed and I don't work in this prosecutor's office in the city of Kremenchuk anymore, and generally the situation looked very strange. As for the fact that in 2004 these documents were as if lost, in 2009 they were somehow found, and about the materials of criminal proceeding, there are documents about the movement of these criminal proceedings that are signed not by the assistant of the prosecutor, that was my position, but they are signed or by the head of the prosecutor's office or by his or her deputy. So I provided the explanation that I don't know about the circumstances under which they were found, and then finally I found out that I was brought to disciplinary responsibility. I would like to clarify the loss of these documents. Let's call it like this. It happened in 2005, 2004. As far as I know, 2004. Okay. How you found out about the loss of these documents? So you saw that they were absent. You were informed about it. No, I was informed about the fact that they were found. But how they disappeared? You say that they were lost in 2004. Miss Natalia, as far as I know it from other people's words. I explained that since 2005, from 2002 till 2004, I worked in the prosecutor's office in the city of Kremenchuk. In 2008, I was transferred to the prosecutor's office in Globensky district in Poltava region. So I worked in other prosecutor's office. So the documents were lost in Kremenchuk prosecutor's office when you were working there. Okay, so I just want to clarify how did you learn about the fact that these documents were lost in 2004? So you worked with them, you saw them, you found out that they were found in 2009. Okay, it is clear. So you were informed, or you found out it from other sources. But how they were lost? What was the sequences of it? Because you were brought to the disciplinary responsibility in 2009. I found out that the documents were lost when they were found. I didn't know that some of the documents had been lost. I wasn't asked about it during all this period. Yeah, so it's detective story, I understand. And again, but did you have any link to this document? So did you know What are these documents? Where they were? Yes, I worked as assistant of the prosecutor's office from the state prosecution. As far as I know, these were materials from criminal proceeding that were sent for studying. As for my functional duties, I started the criminal proceeding at the request of the head of the prosecutor's office, and I provided the conclusion about the completeness or non-completeness of the pre-trial investigation. Then they were transferred to the respectful deputy. Okay, it's clear. So you didn't know in 2004 about the loss of these documents, and you learned about it, found out about it when you were brought to the responsibility. Yes. Okay, it was in 2009. According to you, also you were brought to the other disciplinary responsibility, and it was a result of bullying by one of the heads of the prosecutor's office in Poltava region in 2011. Can you describe the essence of this conflict in detail? What is the essence of this point system, as you call it? And taking into account your principled non-acceptance of such failed system, how did you manage to remain in the prosecutorial bodies for such a long period of time? Why didn't you resign? So you say that you are bullied, you do not agree to the principles, you don't have possibility to change the situation. And the only option is to change the duties. Okay, about the me being brought to the disciplinary responsibility, so I would say that in June 2010 I was appointed as the prosecutor of Semenevsky district in Poltava region. During my work, I had a personal conflict with one of the deputies of the prosecutor of Poltava region. After a year, on the request of this deputy, his employees prepared negative statement for the reunion about the results of work for the first half a year 2011. According to the results, I was brought to the disciplinary responsibility. Here I would like to point your attention to the fact that in prosecutorial body, the practice to be brought to disciplinary responsibility as for results of work for 1 year was absent. I was just appointed at this position and I have just started, and there were no any grounds. If we look at the order, we will see just 5 directions that were taken out of all the general directions, and compared to the previous achievements for the previous periods, it was like decrease in the efficiency. About my long work in prosecutor's office, I had some illusions. I was a young man with graduation certificate in law, graduated with major in law, and I thought that I could work in prosecutorial body. I thought that prosecutor's office performs important functions. I liked to work in the direction of the state prosecution. It was quite difficult because there was big volume of work, but it was interesting. And taking into account the conditions and my capacities, I moved forward through the career ladder, and in one of the moments I achieved this ceiling. After it, I couldn't move forward. And I took a decision to leave the prosecutor's office. Moreover, a new anti-corruption body was established. There was a selection procedure for this body. And I became one of the first detectives who were selected. Thank you. You clarified your attitude. Okay. Then I have the last question. So you claim that you never admitted your guilt of committing disciplinary offenses and did not consider disciplinary sanctions imposed on you as fair. We have heard it from you today. Did you try to receive any materials of these disciplinary proceedings, given the availability of such materials could help refute reasonable doubts? I mean, as of today, in this situation, about your twice being brought to the disciplinary responsibility in case of the selection procedure for a judge of the Constitutional Court. And especially since this question was asked during your participation in previous competitions, because these are well-known facts and they give some origin to some doubts. So what did you do to receive any objective information and to provide some base of evidence due to the fact that you don't think that these disciplinary offenses are adequate? I didn't do anything. I didn't think that in these materials there was something that could be presented for explanation. I cannot agree to you, because if in these materials there are no grounds for bringing you to responsibility, this is the circumstances that will debunk the clarification doubts. Why I asked you this question? Because this is not your first participation in the competition. You have been already asked these questions. And being an adult person with such a background, being a detective from the NABU, you could understand that this question will be raised today. And here we have only your verbal explanation. That's why I am not confident in the fact that I obtained the explanation from you. Yes, I didn't take it into account. Okay. The advisory group knows that from the 1st of March 2021 to the 1st of September 2021, so during the 6 months, you were undergoing internship with attorney Natalia Yefanova. The record book of internship, program fulfillment, and individual internship plan states that on the 16th of August 2021, you were doing the following for 2 hours: obtaining legal practice by means of representing interests of an individual in public authorities, their officials, and public servants. During the interview with the Ethics Council, you were asked similar questions, but you didn't answer them in a sufficiently clear way. So, linked to this situation, my first question is, did you undergo the internship during working hours? No. It seems to me that I responded in a very clear way to the Ethics Council. At first, this internship was not in the working hours. I informed my senior manager from the prosecutor's office it was not during the working hours, and it was in online, in prevalence, and I didn't represent any clients, as I didn't have power and authority to act like an attorney. And how did you pass this internship in your free time?
Was it in the evening, in the morning, on weekends? How was it? Online participation also requires your attention. It was during a non-working hours. I was mostly compiling procedural documents. I was listening to the records of court sessions, and I was communicating with the supervisor. Okay. My next question is whether you consider it as a violation of the legislation. No, I don't think it's a violation of the legislation. I got it. Okay, I understand. From your previous response, I understand that it was not during working hours. I have another question in relation to it. The interest of what people and in which body did you represent during the aforementioned period of time? As far as I understood, there was a record in a journal, but you didn't represent interests of any people. No, I didn't. Upon the request of attorneys, I prepared some documents, but I didn't know about the people they were about. So you didn't do any actions that would be called specific representation of interest. You were not entitled to it back then. Yes, it's correct. The last question. Please explain the circumstances of getting the right to practice law as an attorney on the 11th of October. You got it and lost it on the same day. Do you think it's a violation of requirements for non-competition? No, I don't think so. After the internship ended, I was informed about the date when I can get the certificate with right to practice law. I came there and I filed an application to seize it, because back then I was holding a position in a state body. And did you pass an exam? Yes, I did. Before the internship or after? Before the internship, I passed the exam in the Qualification Disciplinary Commission of Kyiv City. That's it from me. Please, I give the floor to the next rapporteur.
Thank you, Natalia. Mr. Yaromenok, I also have some questions to you. And the first question relates to the time when you and your wife worked together in the NABU. Your wife held the position of the deputy head of the Public Relations Department and the call center of the Public Relations Division of the NABU for 5 years, from 2018 to 2023. And after her dismissal from the position, she filed a claim against NABU on recognizing as unlawful and quashing the order of NABU on termination of civil service and dismissal from 7th July 2023 and her reinstatement at the position. And the claimant, your wife, was convinced that NABU substituted the procedure of release with respect to her with the change in significant conditions of civil service due to the fact that she had guarantees as the mother of a child below the age of 3, which prohibits to dismiss such category of employees upon the employer's initiative, except for instances of complete liquidation of enterprise, institution, organization, when dismissal is allowed with mandatory employment. Besides, the NABU intentionally put her into conditions when she should have been forced not to respond to the severe violation of her rights and guarantees, which would have entailed forced continuation of civil service at a new position. Now, in response to the advisory group of experts' written question, you said that, and I quote, "I'm not aware of the legal justification of my wife's demands stated in her claim on reinstatement at the position. However, I fully support her desire to get justice and restore individual rights." Now, taking into consideration the sensitive character of this case, which directly concerns your family's well-being and your wife's professional career, why didn't you consider it necessary to familiarize yourself with the text of the claim and to give some advice or maybe recommendations? Could you explain this?
Yes, of course, I can explain it. Of course, first of all, I'm not a specialist in labor law. I work in the area of criminal law and procedure. So to give any kind of advice, I would have to go deeply into the subject of dispute, study the relevant legislation, and actually my wife did it before. I don't have any doubts as to her professional qualities, and I think that it is undoubtful that she is able to prepare a claim on her own. That's it. That's everything I can say.
Is your wife a lawyer?
Yes, she's a lawyer. She has a degree in legal science. She graduated in 2010 from Odessa Law Academy, and for some time she worked in prosecutorial bodies. And she was specifically representing the interests of the state and citizens in courts. So she knows more about the subject of the dispute.
This I understand, but what I don't understand is that since you was asked by the AGE to provide more detailed information about this claim and you denied this, don't you think that such a response you have given to us might cause doubts among external observers concerning the honesty? I mean, I understand that you are both lawyers, but you're also a couple, married, you live in a family. So it's quite normal that members of the family discuss such a problematic issue, and the essence of the court case which was initiated by your wife. And in particular because it relates to the same employer, the same institution where you both worked at, so at NABU. So how do you respond to this?
Of course, we discussed it with my wife. She was offended because of the circumstances of her firing, and I gave the explanation that I didn't familiarize myself with the materials of the case, with the claim itself. It's the first thing. Second, I didn't refuse to provide to the AGE any materials. I was asked specific questions and I answered them, but it was not about provision of any documents.
It was a request to provide us more detailed information, and you sent us a written answer. I am not aware of the legal justification of my wife's demands. But now you are saying, yes, of course, we discussed this with my wife. So obviously you was not dishonest. You was not honest with us when sending the written answer to our question. Isn't it so?
No, it isn't so. I was very specific while answering your questions. I am not aware about the legal reasoning, but I know the circumstances because we discussed the circumstances of the firing of my wife with her. I would like to explain once again that I didn't read the claim itself and the materials of the case, because I don't have any doubts as to the professional qualities of my wife, and I know that she can draft all of the documents on her own, and she didn't ask me to help her to provide any recommendations to read the documents. I just explained that I am not a specialist in the area of labor relations, and I never worked in this area, and now I work in the area of criminal justice. I just don't understand what I didn't answer it, in your opinion.
I will not repeat the third time the same question, so I will turn to the next one. Do you consider existence of any conflict of interest because both you and your wife were employed at NABU and had some problems with the management of NABU?
No.
Well, I don't have any conflict of interest personally. Whether there is.
So your wife
Це
had a
питання не до
conflict with
мене.
the management?
У неї не було.
She didn't have any conflict of the management with the management of NABU before her firing. She just thinks that this fact was illegal, with violations of her legal rights. But before she was fired, she didn't have any conflicts with the management.
Thank you. A next question. This relates to your property status. Your wife, as a member of your family, has 33.3% of the apartment with the area of 43.8 square meters in Poltava region, under the right of shared ownership. It is stated that the value of the apartment amounted to only 8 Ukrainian hryvnias as of the date of the right of acquisition, and this was 5th of February 2009, or according to the most recent valuation. Could you explain the fact of such low estimated value of this apartment compared to market prices and circumstances of obtaining of the right of shared ownership?
Так, звісно.
Yes, of course, I can explain it. My wife's parents were employed at the Poltava plant, and they were given the housing. It is not exactly an apartment, because there was no kitchen in it. It's rather like a dormitory, and they used the right to privatization of this apartment, and they used it for all those who were registered at this address. So my wife's parents and my wife, 3 people. And the cost of this apartment was indicated in the technical documents for this apartment. There was no other evaluation of the cost of this apartment, because no other legal deeds were executed as to this apartment, and this evaluation is the last we know about. If you're curious about any taxes and fees, it's not necessary, because it was privatization with no price, so we were not concealing anything or avoiding payments.
Last declaration, it still stated the value of 8 hryvnias. Do you think this is the realistic value?
According to the current legislation, we indicate in the declaration the cost at the moment of acquisition or according to the last evaluation. I explained that the cost at the moment of acquisition was 8 hryvnias. We didn't have any further re-evaluation because we didn't conclude any other legal documents, legal deeds. So the declaration contained the cost we knew about. I cannot invent any other cost. And who defined this cost? The Bureau of Technical Inventarization that issued technical passport for this apartment. If an apartment with an area of almost 44 square meters is divided into 3 people registered there, it appears that it's 14 square meters per person, and they were evaluated at 8 hryvnias. I can only explain it with the fact that probably the plant was taken into account during the evaluation, but it is I'm not sure about it, and it didn't matter at the moment of acquisition. The specialist said it's 8 hryvnias, so 8 hryvnias. Are there any other questions?
I have another question. You mentioned 2 times that you are not expert in the labor law, but you are expert in the criminal law and criminal proceedings. What do you think qualifies you for the position of a judge of the Constitutional Court? What kind of expertise in the field of constitutional law do you possess?
I will explain. I, as a representative of the Bureau, started working with the colleagues since 2015. We did a lot of work during that time, and unfortunately, due to some decisions of the Constitutional Court, some results of our work were suffered, and I, as a specialist in the criminal law, can give my assessment, analyze legal norms, and some decisions of the Constitutional Court are considered by me as unsubstantiated, and I am really sorry about the time and resources we spent that had no results. I think that my experience, professional level, and analytical skills allow me to change my position and become a judge of the Constitutional Court. I am not stating that at this moment I am the best candidate of all those who participate in the selection. It's up to you to make this decision, but I think that my professional and life experience allow me to run for this position. Ms. O'Connor.
For the candidate.
Будь ласка, пані O'Connor.
Ms. O'Connor, please.
I just, something that you just said piqued my interest, more so than the other items. You said you're running for this court. You don't like some of the rulings that the Constitutional Court of Ukraine has handed down that have had, I'm presuming, a negative impact on criminal law or criminal procedure. Is that accurate?
Так.
Yes. The Constitutional Court at one period of time took a number of decisions that consultant made a drawback for anti-corruption reforms implemented in Ukraine since 2004. Some norms were retained as unconstitutional about the law of anti-corruption, of corruption prevention, and some norms of the law of Ukraine on National Anti-Corruption Bureau. So this negatively impacted the structure and all the work done by these bodies.
Let me follow up. Do you think that the decision that was handed down in 2004, is that when, did I hear you say it was a decision from 2004?
No, these decisions were adopted in 2019, 2020, and later.
Do you believe that these decisions were handed down with legal authority to support them, or do you think that they were motivated by something other than sound legal authority?
Unfortunately, the Constitutional Court, since its foundation, has been an instrument of some political games and intrigues, and the source of legal turbulence. I would remind that due to the decisions of Constitutional Court, the usurpation of power was done by the former president of Ukraine, Viktor Yanukovych, and drawback of anti-corruption reforms and a row of doubtful decisions were taken as for non-correspondence to the constitution of some bylaws. And unfortunately, even currently, the Constitutional Court continues to create informational grounds and precedents that do not create good reputation for it. For example, recently, the head of the Constitutional Court was brought to the accountability for corruption-related activity. I believe that today your team has a good chance to implement this selection procedure for the dignified candidates for the Constitutional Court of Ukraine. Unfortunately, the number of candidates is not so big, but I hope that this will be the first step towards the establishment of efficient and independent constitutional body.
Thank you very much.
Василь Іванович Шакун, запитання, будь ласка.
Mr. Vasil Shakun, your question, please. Mr. Roman Alexandrovich, you expressed a thought that all the problems from NABU are problems from Constitutional Court. So this is Constitutional Court's fault that NABU, on some reasons, hasn't met the expectations by the society. So can you mention concretely which decisions from the Constitutional Court of Ukraine, for example, in the sphere of criminal law, created obstacles for the body that you work in to achieve success? This is the first question. And the second one, before blaming the person acting as the chair of the Constitutional Court, it should be mentioned that the chair of the NABU, ex-chair of NABU, is in the list of corruption-related people. Okay, so let's do not be engaged in the discussion. Let's answer the first question of my deputy, Professor Shekun. Okay, at first I would like to correct you. I have never said that Constitutional Court is to be blamed for all the problems of Naboo. I talk about separate decisions when the norms of criminal code were recognized as unconstitutional, as for acquisition of wealth. And the group of cases that were sent to the court were closed because these norms were recognized as unconstitutional. Thank you, Mr. Roman. But this situation can be evaluated in other terms about the legality of the norm implemented and introduced in the criminal code. But okay, this is your opinion. Thank you for it. Are there any other questions? From Mr. Barrett, please.
Follow-on question, and this is following on the questions from my colleague in relation to the disciplinary matters which arose in the prosecutor's office when you were there. So I understand that there were 2 occasions when you were brought to administrative or disciplinary responsibility, and that you disagree with them. You reject the outcome, and yet you have not, from my understanding of what was said, you have not looked for the documents. So an outsider might think that you are rejecting the process but not formally challenging it, which someone might think was sort of mischievous, that you could challenge it, you could reject it, but then not do a formal process. So how would you answer that point?
Mr. Richard, look, I was working in the post-Soviet old prosecutor's office, where decisions about bringing to the disciplinary accountability was accepted voluntarily. It was just a normal practice. After each reunion, the head of the prosecutor's office said that you have reproach, you will have no appraisal or something like this. So it was normal that you were given reproaches and then you were they eliminated it. Now situation changed. At that period there were no acting disciplinary mechanisms as for this disciplinary accountability and fine. If I had addressed somewhere in that period, it would have meant the end of my and termination of my career. I was a young man. I had nowhere to go to work. I worked in a rural location, and to become an attorney in rural location had no very interesting and no very pleasant prospects. So I perceived this situation as an ordinary one for that period. Currently, this reproach are shown to me at each selection procedure and are mentioned, and members of the selection commissions and expert groups have doubts about my integrity. It happened like this. Mr. Roman Alexandrovich, answering the question answering the question of the chairman of the AGE, you explained that what pushed you to submit your candidacy for this selection procedure was the fact that the Constitutional Court of Ukraine adopted a row of decisions, doubtful decisions, that made a drawback started from the 2014 anti-corruption reform. Don't you think that this is quite an emotional decision? Do you see in yourself deep knowledge, promptness, and potential, and awareness, quite in-depth awareness of the constitutional justice to perform duties and functions of the judge of the Constitutional Court of Ukraine? Mr. Yaroslav Mikhailovich, it wasn't an impulsive decision. It was quite a balanced decision about my participation in the selection procedure. And one of the grounds, so the nominated by me circumstances, they were one of the force that pushed me to nominate my candidacy, but these were not main reason. I think that my level of knowledge, my level of proficiency, and my awareness about the legislation in vigor, particularly in the constitutional law, gives me the possibility to perform functions of a judge of the Constitutional Court of Ukraine. And this is the question whether you think like this also. Are there any other questions? If there are no questions, Mr. Roman Alexandrovich, before closing the interview, you are giving 5 minutes of time for your closing remark. Thank you, Mr. Yaroslav Mikhailovich. I think I have already stated a lot answering the questions. I had possibility and pleasure to review the interviews of other candidates, so I understand that my interview went to another direction, and I think that what the other candidates have stated in their closing remarks, I have already said before. That's why thank you so much for your attention. Thank you for your answers, Mr. Roman Alexandrovich. So, the interview of the advisory group of experts with the candidate for the position of the judge for the Constitutional Court of Ukraine, Roman Alexandrovich Yaromenok, is closed.